today. Hi, welcome back to the Legal Pad. Last week I did a presentation before a group of family law lawyers, and the issue of the client trust account came up for discussion. And it reminded me that many lawyers still don't know what's happened with IOLTA accounts, the FDIC, and congressional changes to the protections offered by FDIC. For over 28 years, the FDIC's insurance policy had a maximum limit of $100,000. If you had less than $100,000 in the account, you were protected by the government insurance. Anything over that, that was your problem. If a bank failed, you lost the excess in over and above the $100,000. But as I say, after 28 years, with the financial crisis that we've been experiencing in the last several months, Congress changed the law earlier this year so that the now new maximum is $250,000. Well, many lawyers are dealing with payments for the benefit of clients or receiving money actually from clients that could exceed the $250,000, whether it be family law or debt collection or real property issues. Those funds are transferring through the client trust account. What happens then? If you have in excess of the $250,000, are you still at risk? Well, the FDIC, influenced by lawyers, has now created a new regulation. And the regulation says that if you have an IOLTA account that's designated as such, that's designated as a client trust account, that follows the rules of accounting and the rules of professional conduct of your particular jurisdiction, then whatever money you have in that account for the benefit of a given client, even if in excess of $250,000, will be protected by FDIC insurance. So now we can breathe a sigh of relief. However, there's some requirements here. As I mentioned, you have to have the account identified as a client trust account. You have to have sub-accounts within that so you can clearly identify how much money is attributable to each client who has money in your client trust account. And next, you have to comply with the rules of professional conduct and the rules of accounting within your particular jurisdiction. If you do that, you will be safe. Again, remember that some of the rules of professional conduct, as well as the rules of accounting, require you to have money in your client's trust account only when it's short term and only if it's a relatively small amount. So if you have a relatively large amount, and I'm not sure there's any definition of what that means, and it's going to be for a longer period of time, that money probably should not be in your client trust account, but rather in a separate trust account for the benefit of the specific client. And if you do that, the money does not go into, that is, the interest on that money does not go into the IOLTA account maintained by the State Bar, but rather is attributable to the client. And as such, you want to make sure that the bank has the federal ID number or the Social Security number of your client so that they are given the reporting at the end of the year for tax accounting purposes rather than you and your account. As I said, the rules today favor lawyers, gives us a sigh of relief, but you have to follow the rules and regulations in order to qualify. Thanks for joining us today.